In the vibrant streets of Chandni Chowk, bridal boutiques dazzle with exquisite lehengas and accessories. But have you ever wondered why renowned designers like Sabyasachi and Manish Malhotra haven't taken legal action against the sale of imitation pieces? The answer delves into a complex web of jurisdictional hurdles, resource allocation, and strategic priorities. While these designers fiercely guard their creations, legal battles might not always be the chosen path in this bustling hub of fashion inspiration. Designers might prioritize other avenues to protect their work, like branding and originality. In the dynamic world of fashion, protecting intellectual property rights is crucial to safeguarding creativity and innovation. Welcome to our video on how to enforce intellectual property rights within the fashion industry. Dive into the intriguing world where the law weaves a web of strict rules around the captivating realm of fashion. Unveil the enigma that fashion products born of utility stand beyond the grasp of copyrights, for they are meant to adorn the wearer's canvas. Explore the corridors of the Copyright Act, where sketches, the soulful creations of designers, find shelter under its protective wing as the true artistic treasures. Yet, a twist awaits as a clause within the Act unveils a time sensitive secret. Once a creation multiplies beyond 50, its artistic essence fades and the cloak of copyright slips away. But the plot thickens further. Enter the stage of the Design Act 2000, a guardian of fashion's realm, embracing dresses and jewels within its legal embrace. Journey deeper as silhouettes step into the spotlight, shielded by registration with the controller of designs. From Kolkata's patent office to the branches in New Delhi, Mumbai, and Chennai, this act weaves a safety net. Uncover the two essential conditions: novelty and the dance of registration preceding the grand entrance of the fashion marvel onto the market stage. Step into a world where rules entwine with the charm of fashion and the very fabric of creativity finds protection within the arms of the law. There are three key areas of intellectual property protection: trademarks, copyrights, and patents. Trademarks protect brand names, logos, and symbols. To enforce these rights, first, register your trademarks with the relevant authorities. Second, monitor the market for any unauthorized use. And third, take prompt legal action against infringers. Imagine a trademark in fashion like a special stamp defined by Section 2 of the Trademarks Act 1999. It sets apart others' creations like their products, packaging, and even unique shapes. This special stamp looks at three things: what customers like, who owns the trademark, and who's in the market. So, when a fashion design uses this stamp, it gets protected by trademark law. Copyrights safeguard original artistic expressions, including fashion designs. To enforce these rights, first, document your designs and creations with clear records. Second, consider registering your designs with copyright offices. Third, monitor the market for imitations and copies. Fourth, issue cease and desist letters to infringers and pursue legal action if necessary. In the world of fashion, copyright safeguards designers by recognizing their unique and creative contributions. This covers a wide range of artistic work, even pieces that may not immediately catch the eye. While registering your design is not obligatory, it's a good idea. Interestingly, if a design is registered under the Design Act, its regular copyright protection ends. Patents protect unique and novel inventions. While less common in fashion, they can apply to innovative textile technologies. To enforce these rights, first, obtain patents for your inventions through a patent office. Second, keep detailed records of the invention process. Third, monitor the industry for potential infringement. Fourth, consult with legal experts to take appropriate legal measures. In the fashion world, patents give creators legal control over their creations, whether they are products or unique techniques. To fully secure their ideas, inventors often choose both design and utility patents as part of their smart strategy. Design patents safeguard the look for 15 years from issuance, while utility patents cover function for 20 years from filing. Step into the captivating realm of creativity where copyright becomes a shield guarding original masterpieces. Unveil the exquisite fusion of fashion and art where designers weave their magic to craft not just clothes but a symphony of accessories. Journey through the corridors of the law to discover how copyright laws, as detailed in Section 2C of the 1957 Copyright Act, stand sentinel over the imaginative creations of designers. Explore the canvas of artistic craftsmanship as depicted in Section 2C of the Copyright Act of 1957, a realm of color, sculpture, sketches that tell stories, prints that imprint memories, and designs that define ingenuity. But wait, the plot thickens. Unlike the Copyright Act's leniency towards registration, enter the riveting world of the Designs Act 2000, where the key to claiming security lies in registration with the Controller General. Uncover the intriguing distinction that the Designs Act makes. A design in its realm excludes the realm of artistic work enshrined in Section 2C of the Copyright Act. Embark on a journey of contrasts where legal nuances blend with creative brilliance to shape the destiny of designs. In the dynamic realm of fashion, the intricacies of law often find themselves out of step. Once a design is replicated, the wheels of retraction grind to a halt, leaving room only for outcry and legal action. But stepping onto that stage requires more than just intent. It demands the stature of well established designer. Picture this: designers chasing after countless local boutiques and skilled masteries just to make sure their designs aren't copied. Doesn't it sound super impractical and incredibly tiresome? In a noteworthy instance from 2008, the erudite intellectual property specialist Shwetasri Majumdar led the charge as the advocate for designer Tarun Tahiliani in a high stakes case of patent infringement against Renu Tandon, brought before the esteemed Delhi High Court. The allegation, rooted in Tahiliani's claim that Tandon was marketing kaftans bedecked with his unique patents in Pakistan, gripped the industry. The saga eventually found its conclusion outside the courtroom, orchestrated by a mediator's hand, with Tandon's defense asserting that the contested fabric had been sourced rather than crafted. Seasoned designers like Tahiliani reflect on the labyrinthine paths of justice, which often stretch too long to align with the swift heartbeat of fashion cycles. With a rueful recounting of his own encounters with plagiarism, Tahiliani shared the story of one legal battle that extended for years, evoking a bittersweet memory. I mean, even the printer who printed it had died in between. In this intricate dance between creation and law, the rhythm of justice often struggles to harmonize with the rhythm of trends. A glimpse into the future reveals a tapestry where protection rests not solely in registrations but also in the preservation of the past for the generations yet to come. Embrace this narrative of resilience, adaptation, and the art of securing a slice of the fashion pie in the ever evolving industry. Let's take a look at this 5-year-old story on how two Indonesian men outsmarted global brands like Asics and Onitsuka's Tiger parent company. In the heart of Indonesia, a unique phenomenon is taking place that has left famous foreign brands scratching their heads. Global giants that have invested millions in branding and recognition are finding themselves on the losing end of court battles against seemingly small and obscure Indonesian companies. But how did this David and Goliath scenario come to be? It all starts with the story of two Indonesian entrepreneurs who registered a 70-year-old sneaker logo before global brands even had a chance to realize what was happening. They registered a logo that looks a lot like the one used by Onitsuka Tiger in 1994 for their own sneaker company. The Indonesian trademark law follows a first to file principle, which means that the entity or individual who files for the trademark first, regardless of prior usage, often gets the legal protection. This law has given rise to a unique marketplace where local entrepreneurs can capitalize on famous brand names by quickly registering them and then demanding hefty licensing fees or legal settlements from the actual brand owners. It's fascinating how these small companies can essentially own big brand names just by filing first. But it also feels a bit unfair to the global brands. The legal battles that ensue are complex and often lengthy, with global brands facing an uphill battle to prove prior usage and brand recognition. It's a loophole in the system that's allowing this to happen. While it's a challenge for global brands, it's also a wake up call for them to be more vigilant about protecting their trademarks. As global brands grapple with this unique challenge, they are exploring innovative ways to protect their trademarks, such as monitoring trademark applications, taking preventive legal actions, and even partnering with local businesses. In the ever evolving landscape of international trademark law, the tale of the stolen sneaker logo serves as a reminder that even the most powerful brands can be caught off guard by unexpected legal twists. As Indonesian entrepreneurs continue to test the limits of trademark law, the global business world watches closely, learning valuable lessons about the importance of staying one step ahead in the game of branding. Remember, enforcing intellectual property rights requires vigilance and a strategic approach. In cases of infringement, legal action may be necessary. This can involve cease and desist letters, negotiation, and even court proceedings. Mediation and negotiation are often more cost effective ways to resolve disputes. Settlements can include licensing agreements or financial compensation. Additionally, education and collaboration within the industry can help promote respect for intellectual property rights. Embark on a transformative journey through the corridors of the fashion industry's intellectual property landscape where change begins. The call to action is clear. Fashion's guardians must rewrite the playbook for protection. As the spotlight turns to designers, they are entrusted with an empowering responsibility to embrace the knowledge of IP protection and discern the optimal shield for their creations. At the heart of progress lies the elevation of individual rights, breathing life into a nation's intellectual property journey. And the key to this transformation? Mending the gaps that dot the current canvas of fashion protection, fueled by the ink of legislative reform. In the grand tapestry of strategies, one thread emerges resplendent: the act of registering a brand or corporation name. Within its folds lies the power to safeguard artistic endeavors and creative brilliance from the clutches of unlawful replication and misuse. A fashion brand's destiny intertwines with this act, a shield forged against the misappropriation of ideas and designs. Amidst the grand symphony of protection, the process itself may be a journey of cost and time, yet its fruits extend to the horizon of long term safeguarding. But the narrative doesn't end here. The stage expands to encompass the government's role, one of vigilant guardianship. Emerging forms of brand mimicry becomes the focus, demanding a legislative embrace to shield the original from the shadows of imitation. In a dance of counterfeiters and creators, education becomes the common chord that harmonizes their understanding of innovation's essence. As the curtain rises on this saga of transformation, one truth emerges. The evolution of the fashion industry's protection narrative is not just a story of laws and legislations. It's a tale of empowerment, of creators wielding their knowledge as a shield, of a nation nurturing its intellectual landscape, and of a thriving ecosystem where innovation reigns supreme. The fashion industry thrives on innovation and creativity. Enforcing intellectual property rights ensures that designers are rewarded for their hard work and originality. Thank you for joining us to learn about enforcing intellectual property rights in the fashion industry. Remember, protecting your creations benefits not only you but the entire fashion community.